Good morning, everyone. Today we will discuss another very important topic, that is ESOP, the Employees Stock Option Plan. We'll discuss how ESOPs are issued, the different stages involved in an ESOP issue, the purpose behind issuing ESOPs, who can issue them, the legal requirements, and the tax implications arising therefrom. So let us begin our discussion. There are broadly three stages in any ESOP issuance. Number one is granting, number two is vesting, and third one is exercise of option. The first stage is the granting stage. Granting refers to giving a right to an employee to acquire shares of the company at a predetermined price after the vesting period is over. The second stage is the vesting stage. The vesting period refers to the period between the grant of option and the date on which the employee becomes entitled to exercise the option and acquire shares of the company. Under law, the vesting period cannot be less than 1 year. However, it may be longer depending upon the objective of the organization. For example, if an organization wants to retain an employee for say 2 years, it may prescribe a vesting period of 2 years. After completion of the vesting period, the employee becomes entitled to acquire the shares or such a number of shares as have been vested in him. These shares are issued to the employees at the predetermined exercise price. Now the question arises, who can issue ESOPs? ESOPs can be issued by startups, listed companies, and also by unlisted companies. In case of listed companies, the applicable SEBI regulations and guidelines must be complied with. ESOPs may be granted not only to employees of the company but also to directors and employees of the holding company or subsidiary company. However, in case of directors, certain restrictions apply. ESOPs cannot generally be granted to a director belonging to the promoter group, a director who is related to the promoter, a director holding more than 10% of the equity share capital of the company. However, these restrictions are relaxed in the case of startup companies, subject to applicable law. Now let us turn our attention to the most crucial aspect, that is taxation of ESOPs. When an employee exercises the ESOP and acquires shares of the company, the difference between the fair market value, that is FMV, of the shares on the date of exercise and the exercise price paid by the employee is treated as a perquisite under the head salary. Accordingly, such amount becomes taxable in the hands of the employee as salary income, and tax is payable according to the applicable income tax slab rate. The second taxable event arises when the employee subsequently sells the shares acquired under the ESOP. At the time of sale, the difference between the sale price of the share and the fair market value considered at the time of exercise is treated as capital gain. Such capital gain may either be short-term capital gain or long-term capital gain depending upon the period of holding. In case of listed shares, if the shares are sold within 12 months from the date of acquisition, the gain is treated as short-term capital gain and the tax is payable under section 111A of the Income Tax Act at the rate of 20% plus applicable surcharge and health and education cess, subject to fulfillment of prescribed conditions such as payment of security transaction tax. If the shares are held for more than 12 months, the gain is treated as long-term capital gain and tax is payable under section 112A of the Income Tax Act at the rate of 12.5% plus applicable surcharge and health and education cess, subject to applicable exemptions, threshold limits and other statutory conditions, including payment of STT. In case of non-listed company, in cases where the conditions prescribed under section 111A or 112A as mentioned above are not satisfied, the capital gains shall be taxed at the rate otherwise applicable under the Income Tax Act. We will take up the misuse and misapplication of ESOPs in our next video, that is episode number 45. Thank you so much. Thank you.